Continuation of the bail application, State versus Cholota, in case 497 of 2024. As it pleases the court.
As it pleases the court.
Have you compiled the
Replying affidavit.
Good morning, Your Worship. Indeed, we have. We have it in writing, and we would like permission to read it into the record.
Thank you very much.
Sorry, Your Worship. I was asked to clarify by my attorney that the manner in which we have responded to paragraphs is denying at the end. He thought that was peculiar when he did that. Okay. The applicant's reply affidavit in support of bail application. I, the undersigned, Moroadi Cholota, do hereby make oath and state I am an adult female currently being held at Magistrate, Bloemfontein. I'm a South African citizen with identity number 8702-100-934085. In this affidavit, I intend on responding to the state's affidavit compiled in support of their opposition to my bail application. The facts contained herein, save where expressly indicated to the contrary, are within my own personal knowledge and belief and are both true and correct. Where I make any submissions of a legal nature, I do so on the advice of my legal representatives, which advice I accept as correct. In this affidavit, I will therefore respond only to those allegations which are relevant to these proceedings. To the extent that I have not responded to a paragraph, those paragraphs should be considered denied. Responses ad seriatim. Add paragraph 1. This paragraph is admitted. Add paragraph 2. Save to deny that the J15 is read with the Deputy Secretary of State's extradition warrant or order. The contents of this paragraph are noted. Add paragraph 3. The contents of this paragraph are denied. Add paragraph 4. The state sets out charges in paragraph 4 that are incongruent with the charges as they are reflected in the charge sheet. In explanation of this, the state inserts a footnote in which it explains the following. While the charge sheet reflects that Ms. Cholota faces numerous money laundering charges, her extradition was not granted in relation to those charges, and accordingly, the state is unable to pursue any money laundering charges against her, as well as the alternative charges on the counts of fraud, on the fraud counts. The state has not amended my charge sheet, nor has the state informed my legal representatives that it will be dropping some of its trumped-up charges against me at the instance of the United States. Instead, the state inserts paragraph 4.1 in its papers, which reflects an amount of 86.5 million that is not found anywhere in the current charge sheet. I am advised that this is an appalling display of the state's disregard for lawful and constitutional criminal procedure. I submit that this is something my legal representatives will challenge using the appropriate court processes in due course. Save as aforesaid, it is denied that the charges reflected in this paragraph are the charges that I face currently. Add paragraphs 5 to 7. Save to state that a proper case for opposing bail on the basis that I am likely to evade trial has not been made out by the state, and that the interests of justice permit my release on bail. The contents of these charges are noted. Add paragraph 8. I deny the contents of this paragraph. Specifically, I deny the allegation by the state that I had no intention of returning to South Africa to face trial. the state has failed to run the criminal trial since 2020, when the charges were originally brought against my co-accused. It also failed to run the criminal case since I was initially charged in 2021. It therefore cannot be said that I have evaded a trial that was never underway. I deal more with this aspect at paragraphs 50 to 61 herein. Add paragraphs 9 to 26. I am advised by my legal representatives that the Constitutional Court held that prosecutors are under a general duty to place before a court any information relevant to the refusal or grant of bail. The allegations contained in these paragraphs present an attempt by the state to distort the information relevant for this honorable court in making its decision whether to refuse or grant bail. The state claims that the Constitutional Court considered its answering affidavit responding to my founding papers and dismissed the application for review of the minister's decision on 26 July 2024. This is wholly incorrect. The Constitutional Court did not consider the merits of my application for review, only the question of urgency on direct access. For this reason, the order of the Constitutional Court attached by the state to its own papers states that the Constitutional Court has considered the application for direct access. It has concluded that no case has been made out for urgency or for direct access. Consequently, direct access must be refused. Crucially, in these paragraphs, the state attempts to make the case that I am a flight risk and that I will evade trial and abscond if I am not remanded in custody. I have already stated previously that this would be a gross violation of my rights under Section 12(1) sub A of the Constitution. I submit further that remaining in custody until April 2025 would also defeat the ends of justice. The state attempts to use the extradition proceedings to prove to this honorable court that I am a flight risk. I am advised that this is a legally unsound approach. The extradition proceedings in the United States were initiated by the state without prior notice to me about any hearing date for trial that I had to present myself on. When it was initiated in 2022, the state had not even set the matter down for hearing. I was busy with my studies at Bay Atlantic University in Baltimore, Maryland, attending lectures and not evading trial or fleeing from justice as the state has made it seem. The state has never put up any communication to me or my legal representatives of any date for trial in 2022 or a request that I attend trial, nor did I ever forward any communication to the state that I had no intention to attend my trial. The state makes reference to undertakings given by former lawyers in January 2023 and May 2023. However, by then, the state had already instituted its request for extradition from the USA. The intention in that has always been to degrade, humiliate, and effect cruel punishment on me for what the state deems as a failure to cooperate with it. It does not mention that the cooperation it sought was me making untrue and false statements confirming facts I did not know in relation to specific individuals. I deal in further detail about this later in this affidavit. The extradition proceedings are elevated by the state to something they are not, in order to maintain this narrative of me being a fugitive from justice, when this simply is not the case. I submit that this is why the state claims to not have possession of the extradition order by Magistrate Judge Aslan of the Maryland District Court, where the order for certification for extradition was granted. Fortunately, my legal representatives were involved during every step of the process together with the court-assigned U.S. attorneys and have possession of the order. It is attached here to and marked NC2. It is also for this reason that I submit that the state has intentionally concealed this documentary evidence when it is legally required to make all documents available to this court. In the judgment, the U.S. judge clearly explains that, firstly, an extradition hearing is not a full trial. Secondly, that extradition has a limited purpose. Thirdly, that extradition is an executive, not a judicial function. Fourthly, that the U.S. court's role is merely to determine whether the legal requirements for certification are satisfied. Fifth, that the crime alleged to have committed is an extraditable. Fifth, that the crime alleged to have been committed is an extraditable offense under the extradition treaty. After the certification, the judge indicated in her judgment that the final decision would be made by the Secretary of State and that submissions could be submitted to him. My legal representatives submitted submissions as requested, yet the state in its affidavits represents this as an attempted appeal of the decision in a bid to avoid coming back to South Africa to face trial. This is not true or correct. This is not true or accurate. The state also states that my remand into custody for nearly 4 months was due to my own making. This too is not true or accurate. As my current legal representatives were also my legal representatives during my extradition proceedings, the accurate fact is that the state, by way of an affidavit deposed to by Advocate Donation, claimed that I was a flight risk with connections in Kenya. On this basis, the U.S. attorney informed the court that I could not be released on bail because I was a flight risk with connections to Kenya. There was no way of disproving this alleged fact by the state in the United States without first challenging it in South Africa. Hence, the bail attempt was abandoned. Interestingly, the state and Advocate Nation are absolutely silent on any allegation that I have connections in Kenya, which I do not and have never had, in proceedings before this honorable court, which is peculiar. At paragraph 25 of the state's affidavit, it is claimed that not all the papers filed in the Constitutional Court have been attached by the state, open quote, to avoid prolixity, close quote. The document the state does not attach is the replying affidavit I filed with the Constitutional Court. I submit that the state did not attach the replying affidavit in order to conceal the affidavit referred to above, dated August 2023, in which Advocate Donation informed the USA at page 2 that, open quote, the position of Ms. Cholota will be the same once the extradition has been completed. Once she arrives in South Africa, she will be formally arrested and transported to Bloemfontein in the Free State province, to appear in the district court. She will, in all probability, apply for bail, which may be opposed by the prosecution, due to the possibility of her being a flight risk, her connection with Kenya, and the outcome of the extradition. The United States had no reason to believe that a national prosecuting authority would fabricate information that crucial, and so relied on it as well. The affidavit by Advocate Donation is attached here too, and marked NC3. The state's complete silence on any mention of Kenya, together with the failure to attach the Constitutional Court filing that makes reference thereto, is indicative of the fact that the state indeed fabricated that information, as there is absolutely zero basis therefore. I have never had any connection with Kenya. I submit that the state has not only failed to observe its duty to place all relevant information to the refusal or grant of bail before this honorable court, but has also attempted to distort the facts in a weak attempt to make a case that I might be a flight risk. The simple fact above all that is relevant to this honorable court is simple. The interests of justice require that I be released on bail pending the hearing date of this trial. The state's opposition is brought in the utmost bad faith and is as weak as its case against me in the main criminal matter. Save as aforesaid, the allegations contained in these paragraphs is denied. Add paragraphs 27 and 28. The contents of these paragraphs are noted. Add paragraphs 29 to 33. The state indicates in these paragraphs that it has appointed a private company, FTI Consulting, to undertake a forensic investigation of me. The report of the forensic investigator is dated 6 June 2023. The state alleges that a copy of the forensic investigator's report was sent to the United States authorities in support of the extradition request. I am advised that the extradition request was sent to the United States in 2022, which means that the state went to the extent of contracting a private company of forensic investigators to search for more evidence to create the impression of a credible case to the United States. It also supports my contention in my founding papers of the weakness in the state's actual case against me and the lack of evidence. As stated previously, the asbestos project has been investigated at length by other state agencies over and above the State Capture Commission, such as the Public Protector, the Special Investigation Unit, and the Auditor General. In none of these reports was I ever mentioned, let alone implicated. It speaks volumes of the lengths the state would go to falsely accuse a person, that it would even contract private forensic investigators. I am advised that the problem with such an appointment is private forensic investigators do not owe the same constitutional duties that the National Prosecuting Authority does, nor are their methods of gathering evidence regulated by NPA legislation and the Constitution. I am advised that the state has contracted out its constitutional duty in paying a private company to look for evidence against a person instead of the investigators employed by the state. It is an unnecessary waste of public funds and was clearly a futile waste of time, as nothing in the FTI Consulting's forensic report links me in any way to the asbestos project. Save as aforesaid, the allegations contained in this paragraph are denied. Add paragraphs 34 to 44. I have resided in South Africa for my entire life prior to my leaving for the United States to commence my studies in political science at the Bay Atlantic University in Baltimore, Maryland, in the United States of America. The context is clear from a holistic reading of my founding papers in their entirety, but I clarify this accordingly to avoid any confusion. The state's allegation that I am a flight risk that never returned from the USA to attend my trial is far-fetched and rather untenable. I was already a student at Bay Atlantic University when the Zondo Commission sent me summons requesting me to appear before it and give oral testimony. I traveled from Baltimore, Maryland in the United States to Johannesburg to give my testimony. The state does not have any communication from me refusing to attend trial. It is well known that despite the fact that my co-accused were charged in 2020 and I in 2021, the state has yet to start this criminal matter. My undertaking was that I would return to South Africa to attend trial. No such trial has ever been set down for hearing before the state filed a request for my extradition in 2022. The state then appears to abandon the request for 2 years. The trial itself showed no sign of being set down for hearing. And I continued with my studies in the United States. The investigators knew where I was and what I was doing at all times. They knew I was in Baltimore, Maryland, attending university. I never evaded any trial, as no such trial was ever underway. The state simply opted to file a request for my extradition without sending me any request to return to the country, nor any indication that the trial was to start. I submit that this was done unnecessarily, but the state's motivation for taking that course of action will become clearer later in this affidavit. Save as aforesaid, the contents of these paragraphs are denied. At paragraphs 45 and 46, the state admits that I indeed do not possess a passport or any travel documents. I further submit that over and above not having possession of a passport, I also do not have a valid identity document or ID card or bank card or anything that could facilitate the application for travel documents, let alone leaving the country. The state claims that the above notwithstanding, nothing would prevent me from applying for a new passport. I unfortunately do not share in the state's rather dim view of the Department of Home Affairs, as I am of the view that the department would be able to detect and report to authorities any attempt by me to apply for a passport or travel documents. I reconfirm to this honorable court the undertaking I made in my founding papers that should I be released on bail, not only will I continue to attend my trial, but I will also not abscond the country, nor will I make application for a new passport or travel documents. Save as aforesaid, I deny the allegations contained in these paragraphs. Add paragraphs 47 and 48. The contents of these paragraphs are noted. Add paragraph 49. The state claims that it is unknown how I managed to fund my living expenses in the US. The Bay Atlantic University in Baltimore, Maryland, at which I pursued a degree in political science, awarded me a full scholarship only for my tuition. The bursary from the South African government was to assist with living expenses. When my bursary was cancelled for no reason in 2022, I decreased my expenses and lived off of my scholarship funds from Bay Atlantic University. The state also calls into question how I am funding my legal expenses. I am advised that I have no duty to disabuse the state of whatever misguided notions it may have as to the payment of my legal fees. The state claims that this is a logical question. I submit that there is nothing logical about this question or allegation, save to assert that like any accused person, I have the right to legal representation. Save as aforesaid, I deny the contents of these paragraphs. Add paragraphs 50 to 53. The state alleges that it disputes my intention to have my son return to South Africa. I am not certain how one's intention can be disputed. I am advised that for the purposes of this bail application, I was required to inform this honorable court of any relatives I have living beyond the borders of South Africa, and I did that in informing on the whereabouts of my son. Taking issue with my intentions related to my son indicates once more an attempt by the state at bolstering the misguided opposition of my bail on the ground that I am a flight risk. I am advised that my bail application on Schedule 5 requires that I show that the interests of justice permit my release on bail, not that I show exceptional circumstances, as would be the case on a Schedule 6 application for bail. The state seems to treat their opposition to my bail as though I am required to show exceptional circumstances, which I am not. Save as aforesaid, the contents of these paragraphs are denied. Add paragraphs 54 to 55. Save to confirm that the state has no information in relation to any issues related to immigration, because I have no such issues presently pending. I note the contents of these paragraphs. Add paragraphs 56 to 58 and 63 to 66. It is of great importance that I deal with the contents of these paragraphs comprehensively and clearly. I am advised that settled law requires that prosecutions must commence and continue only where reasonable and probable grounds for prosecuting exist. The state has attached to its affidavit email correspondence between me and the state prosecutor, Advocate Dinyeshan, at the start of this whole ordeal on 17 and 18 November 2020 at Annexure 12. I wrote the following in that email correspondence to him. 1. I feel it was unfair to me when the prosecutor announced in court and in front of TV cameras that I am a state witness without my knowledge. 2. I am confused because as a PA in the Premier's office, I was nowhere near SCM of departments or the Department of Human Settlements. 3. I feel like you are ordering me to be a witness on something I have no intimate knowledge about. This is seriously worrying to me, and I don't feel safe anymore, especially since I was also visited by the FBI here in the USA. 4. Please don't confuse my ignorance with a reluctance to assist my own country in an investigation, but I feel that you should have had the courtesy to consult with me before you went public on a contract that I still do not have any details on. 5. I would appreciate if your investigation officer or you can send me information that shows my relevance or what you will want me to be a witness about. The following day, Advocate Dinyeshan reassured me and wrote as follows, as set out in the same email at Annexure 12. 1. Good morning. At least it is morning in SA. You have submitted affidavits and testified before the commission. I am satisfied with your version. There are only a few aspects that I want to clarify with you. 2. So at this stage, to answer your question, you will basically be required to testify what you have stated in your evidence, before the commission read together with your affidavits. 3. They were under the impression that you were a future accused, which position I had to address in court. I also had to put it clearly on record that you are a witness for the state. 4. I understand your fear for having to testify about something you do not have full details about, but please rest assured, you are but one of a great number of witnesses in a much bigger picture. I will not expect you to testify about aspects that you do not have knowledge about. 5. The assistance of the FBI was requested for the plain and simple reason to locate you and inquire from you whether you will cooperate with the SA police and the prosecution. 6. I was pleased to note that you had, and I believe still have, a positive attitude and that you will cooperate with us, which we appreciate. The involvement of the FBI must therefore in no way be seen as a negative towards you or your safety. This email exchange, which the state attached to its own papers, shows that I never consented of my own accord to be some sort of special witness for the state. The state announced on national television, without consulting me, that I had agreed to be a state witness. I emailed them to question this. The state prosecutor then reassured me as to why he had done this and made plans for his investigators to come to the USA to interview me, as I saw no reason to emphatically refuse to be a witness. As he told me, there was already a great number of witnesses. As I already have stated in my founding papers, when the investigators came to the USA, instead of interviewing me on the testimony I had provided before the Zondo Commission, they pressed me for more information I had no knowledge about. They, open quote, pushed me, close quote, for further information regarding aspects I could not confirm. And when I got to a point where I refused to agree to testify about things I did not know, they branded me as uncooperative and threatened me with charges if I did not cooperate. Tellingly, the state alleges at paragraph 58.4 of their answering papers that their utterances were, open quote, not a threat, but a fair warning, close quote. I'm glad to see that the state attached the affidavit they filed in the Constitutional Court to their answering papers, in which they clearly admit that they pressed me for specific information I knew nothing about, and when I couldn't or wouldn't, the investigators, Captain Kallis and Brigadier Gerber, called Advocate Denieshan, and the three of them, open quote, discussed the possibility of the state charging her criminally alongside some of the accused if she did not provide full answers to us, close quote. Page 8, paragraph 27. I have also noted that the state told the Constitutional Court in the sworn affidavit they filed that, open quote, the fact that Ms. Cholota did not attribute certain instructions to her former boss had the result that she was treated as a suspect in relation to some of the same charges Mr. Magashule, her former boss, was facing, close quote. This is clear confirmation of the unconstitutional basis that the charges were brought against me. The charges were as a result of me not implicating Mr. Magashule in what the state's investigators wanted me to implicate him in. As I told the state prosecutor right at the outset, I was nowhere near supply chain management and knew nothing about the asbestos project nor the Department of Human Settlements. I am glad, however, that the state has attached these documents to their papers in this application so that other people and witnesses who have voluntarily agreed to assist in investigations can see how the state will potentially treat them. 1. The state will give assurances as to what they require testimony on and turn around and renege on those assurances. 2. The state will then pressure and coerce you to give specific information to them, and when you refuse, the state will threaten and intimidate you with charges. 3. In the event that you remain resolute and refuse to be threatened and intimidated, the state will falsely charge you and hire private forensic investigators to conjure and find evidence against you. 4. When you are still resolute, the state will claim you refuse to attend a trial that has not been started and bring extradition proceedings against, wherein you are accused of being a fugitive from justice, going to the extent of deposing to affidavits, claiming that you are a flight risk with connections to Kenya so that you are refused bail. 5. The state will then ensure that you are humiliated and subjected to cruel and degrading treatment by parading you before the media, shackled and under heavy guard. And 6, finally, the state will unreasonably level opposition against your release on bail so that you remain in jail and deprived of your liberty, ensuring the use of those bail proceedings as a punitive measure against you. I submit that it is surprising then that the state appears offended when their actions and conduct herein is classified as being similar to apartheid-era tactics. They allege that my version, which they have corroborated in their own documents, is defamatory. But I am advised that the truth is not defamatory. Save as aforesaid, the contents contained in these paragraphs are denied. In any event, the purpose of my application is specifically to deal with my bail application and what is relevant to the Honorable Court to consider in its decision. At paragraph 59, the contents of this paragraph are noted. At paragraph 60 to 62 and 67, the allegations contained in these paragraphs are denied. The state alleges under sworn affidavit before this Honorable Court that the Constitutional Court has found the state's conduct to date pertaining to my arrest to be unobjectionable. I submit that it baffles the mind why the state would make such an untrue and incorrect statement so boldly. The state also alleges that the United States found a case against me. As has been shown elsewhere in these papers, the U.S. District Court had a limited and procedural role in these proceedings and considered only whether the requirements for extradition were met, not the merits of the matter. I am advised that the golden thread of bad faith and distortion of facts by the state in this case is patently unconstitutional. At paragraph 68 to 70, I deny that I abandoned any attempt to apply for bail in the United States. The contents of these paragraphs are noted. At paragraphs 71 to 76, I deny the contents of these paragraphs. The assertion by the state that owing to the fact that my co-accused were resident in South Africa at the time that they were charged, the assertion by the state that owing to the fact that my co-accused were resident in South Africa at the time they were charged, they were not considered flight risks is rather absurd. I am advised that on this logic, the state can only oppose bail application on the ground of flight risk if they live, work, or study overseas. I am advised that on this logic, the state can only oppose bail applications on the ground of flight risk if they live, work, or study overseas. Equally perplexing is the assertion by the state that it did not oppose bail in relation to my co-accused, as they did not oppose any legal proceedings to avoid being arrested and charged. Apart from the fact that I did not oppose legal proceedings to avoid being arrested and charged, the state cannot use these bail proceedings as a punitive measure. I am advised that the case law is clear against the state using bail as a manner of punishing accused persons and justifying their deprivation of their liberty. At paragraph 77, the contents of this paragraph are noted. At paragraphs 78 to 83, the allegations contained in these paragraphs are denied. At paragraphs 84 to 88, the state argues in these paragraphs that the amount of 2,500 rand I have requested my bail be set at is far too low and suggests a bail amount like the other accused in the matter of between 50,000 and 500,000. What the state fails to recall is that the individuals I have been charged with are wealthy businessmen, politicians, and top government officials who are gainfully employed. As I stated in my founding affidavit under my current circumstances, I am unemployed and have been since I commenced my studies at Bay Atlantic University in the United States. I therefore cannot afford bail of a sizably higher amount. I am advised by my legal representatives that in the second bail application made by Mr. Oscar Pistorius in December 2015, the state did not oppose his Schedule 5 bail application, despite the fact that he was already a convicted murderer at the time and a flight risk. What I am advised is important for the present point, however. is that the state accepted that Mr. Pistorius could only afford an amount of 10,000 rand bail as he had little to no income at the time. If the state found no objection to the low bail amount in that instance, I submit that it is rather astounding that they find objection to the fact that I can only afford 2,500 rand for bail. Once again, the selective application of equality by the state in this matter emerges. What also emerges once more is the use of these bail proceedings by the state as a punitive form of punishment. Save as aforesaid, the allegations in these paragraphs are denied. At paragraphs 89 to 93, the allegations contained in these paragraphs are denied. Conclusion. It is submitted that I have made out a case for my release on bail. I submit that the contents of this affidavit clearly show that it is squarely in the interest of justice that I be released, and that the state's case against me opposing my bail holds no water. Signed at Bloemfontein on this 15th day of August 2024, Nomalanga Moroadi Cholota. Thank you, Your Worship.
Thank you, Ms. Cholota. Do you confirm that this is your affidavit and that it's correctly recorded?
Yes, Your Worship, I do confirm.
Thank you. I'll receive it. It will be Exhibit D.
My apologies, Your Worship. I did not get enough sleep last night. I wish to beg a leave to hand up the affidavit.
Thank you. So do you close the application now?
I confirm, Your Worship, that I close the application for bail on behalf of the applicant.
Thank you. Applicant Denise?
As it pleases the court. Your Worship, I assume that the applicant will address the court first, and then I shall answer if it so pleases the court.
So you do not have to, or you don't want to present any further affidavits?
No, Your Worship. Thank you.
Thank you. Please proceed.
Your Worship, could I please request a standing down of 2 hours just to allow my attorney to print out the heads of argument. We had issues this morning printing out our written submissions, and we will be back to present orally thereafter at the instance of the court.
Thank you. What is the time now? 11. 1 o'clock.
Indeed, that is fine, unless after lunch, but 1
No,
o'clock is fine
let's
with us.
see. 1 o'clock? You'll take your lunch now. You'll take your lunch now. Thank you. Let's a nice in the time. Would you be able to take your break at this stage and then we can continue at 1?
I've got no problem. May I also, Your Worship, at this stage already hand to the court my heads of argument in this matter, just to save some time?
Does the defense have a copy of it too?
Yes, they do.
I confirm it. Too.
Thank you. That will be it. All of you are excused. I'm aware of one other matter that I just need to attend to before I will adjourn, so all of you are excused for now. You may stand down now.
relevant for the information, or rather for the information that is relevant for the consideration of this court. Right at the outset, we wish to highlight the fact that the state deals with merits with the full knowledge that we do not have access to the docket. And so even if we wanted to meet the state at the point at which we are arguing on the basis of merits, we cannot do so, as indeed, as they say in their answering affidavit, we do not have access to the docket. Quite apart from the fact that bail proceedings are not the actual main hearing and criminal proceeding, and so we would not have dealt with the merits in any case. We are in any case precluded from doing so, owing to the fact that we do not have access to the state's case in order to meet it. That notwithstanding, the state still insists on dealing with the merits of this matter. On Tuesday, we cited briefly authority from the Supreme Court of Appeal in S versus Viljoen, where courts were cautioned from treating the bail proceedings as a dress rehearsal. And we wish to restate that with emphasis in these oral arguments today, to say one of the reasons also that we have not dealt with each and every single allegation made by the state is because this is not a dress rehearsal for the criminal proceedings, and so we would like to focus only on proving that the interests of justice permit Ms. Cholota's release on bail. We submit that the state has failed to satisfy the requirements of Section 60, subsection 4b. We deal with the settled law on bail, on release on bail at our in our heads of argument at page 4. I beg your pardon, Your Worship. And we deal there with firstly stating that it is tried that a bail inquiry is a judicial process, and that it has to be concluded impartially and judicially and in accordance with relevant statutory and constitutional prescripts. It will be recalled that on Monday, the state had a passing comment to the extent that we referenced quite substantially to the Constitution. However, the case law is rather succinct in the sense that both the relevant statutory and the relevant constitutional prescripts need to be taken into account when we are dealing with bail. So Section 60 must be read with the provisions of the Constitution, and a determination of bail and whether or not it is in the interest of justice must then be undertaken. And so we state that right at the outset, and we also then deal with the fact that a refusal of bail without lawful justification is an unlawful deprivation of a person's liberty. We state also that if Ms. Cholota were to be deprived of her liberty on the basis of the state's case, that would be unlawful, as the state has not provided a lawful basis upon which it could be said that it is justified that the interests of justice do not permit her release, as they set out in their papers. We maintain that in all that the state says, there's nothing that meets an argument to say this is what the interests of justice are, and this is why Ms. Cholota does not fall under this. All they say is that she is a flight risk. As to the evidence that they provide, the evidence is flimsy, and we shall get to that in a second. And so we set out the settled law on the application for bail, and then we quote a case there from S versus Majali in the South Gauteng High Court, which held that the power to grant bail must be exercised consistently with the nature and purpose of Section 39(2), and that in considering granting or refusing bail, the court must promote the spirit, purport, and objects of the Bill of Rights. And so it's not enough that consideration is had to Section 12, Section 9, but in the granting of bail, or in the consideration of whether or not to grant bail, the spirit of the Bill of Rights must be considered. And so we end there with a quotation from the court in Majali that says that the application of constitutional norms to the law and practice of bail obliges judicial officers to harmonize Section 60 bail provisions with constitutional norms and imperatives. And we add that emphasis there. And so right at the outset, our particular application for bail is done, or rather is underpinned by the values, the foundational values of the Constitution, and we have consistently in these proceedings pointed to the relevant constitutional provisions, and we have given enough factors and enough information to justify why it is that we deal with those sections and why it is that we state that it is applicable to Ms. Cholota in this particular instance. And so from our founding papers to our replying papers, the main themes there are her arbitrary deprivation of liberty, but also the right to equality. We consistently maintain that should she be deprived of her liberty and detained and refused bail, that would be incongruent with the rights that have been afforded and enjoyed by her co-accused, which is their right to liberty and their right to be released on bail. And then, Your Worship, we set out just a brief summary of our client's case for bail. We set out that she set out her family, emotional and occupational ties, that she set out the assets that she holds. The state appears to take a particular point with the fact that she did not set out what will happen to those assets, where those assets will go, what she does with those assets. We maintain that the requirements of Section 60, subsection 4 require that the accused simply set out what assets they have in order for the court to determine whether or not they have sufficient assets to hold them, or rather to keep them in the country. It's not for her to indicate, I will do this with this asset and do this with this asset and do this with this asset. The legislative requirements are quite clear that that is what she needs to set out. She also set out at length her travel documents, why she does not possess travel documents. She then, in her replying affidavit, went over and above that and provided the fact that she does not even have identity cards, bank cards, anything that would even allow her to apply for travel documents or a passport. And so we felt that that was more than enough to satisfy that provision, that she's required to set out the means and the travel documents in her possession. The state appears to then state that even though she does not have those things, she could still apply for a passport. We reject that assertion by the state wholeheartedly because, again, as we expressed in the replying affidavit, that takes a rather dim view of the capabilities of the Department of Home Affairs, in that they would not notice that someone who is under strict bail conditions, should she be under those strict bail conditions, is applying for a travel document and then likely to evade justice. She also sets out why she will not evade justice. She states that she actually has an interest in preserving, or rather defending, her name and restoring her reputation, as she believes it has been tarnished by all the reports that have gone out there and all the misinformation that has speculated about what she was doing in the US, that she was a fugitive from justice, that she evaded authorities in the US, none of which is backed by any factual evidence. And so that is also one of the reasons she will not evade trial, because she does want to sit for this hearing, have it conclude, and have it come to the result that she has always known all along, and that is that she is not guilty of any of the charges that have been leveled against her. And in summarizing her case, we then referred to the decision in S versus Smith, in which the approach there was that courts will adopt an approach where a court will always grant bail where possible and will lean in favor of and not against the liberty of the subject, provided that it is clear that the interest of justice will not be prejudiced. It would appear from a reading of the state's case that they appear to want to, or to prefer, that this court would lean away from Ms. Cholota's liberty instead of leaning in favor of. And there's no reason that that should happen, particularly because that would defeat the interest of justice. And there's no reason for a court to decide in that manner when there is no evidence in support of the fact that the interest of justice do not permit her release. And so we state there that the liberty of Ms. Cholota is governed not only by the provisions of the CPA, but also, and perhaps more importantly, by the Constitution. we set out briefly the particularly relevant sections of Section 12 of the Constitution, which we read with Section 35 of the Constitution, which deals with fair trial rights of detained persons and accused persons. And we reiterate there that everyone has the right to freedom and security of the person, and this includes the right not to be deprived of freedom arbitrarily or without just cause. And also that this right includes the right not to be detained without trial. The state appears to call for detention without trial. Now, when one considers the fact that the state has taken about 5 years to get to the set-down date of April next year, this would mean that if the track record of the state remains the same, Ms. Cholota would be detained without trial for 2, 3, 4, 5 years. We do not know at this stage. They seem emphatic that the court case will start next year, but that has not proven to be the case in the past, which is why one of the reasons she did not avail herself for a hearing, because none such hearing ever took place. And so we state that it's not just about her release in these particular proceedings, it is that what would happen if the matter were to prolong and be postponed indefinitely. Would that mean that she is in jail or she is detained for that period of time? And so the interest of justice permit her release now, but also the interest of justice permit that it be considered that she might be, if she's deprived of her liberty, sitting in detention for much longer than has been envisaged or that then has been argued by the state. We then also call into question, or rather lean on the equality rights under Section 9 of the Constitution, which guarantees that everyone is equal before the law and has the right to equal protection and benefit of the law. We state that her co-accused have that enjoyment of the law, or rather the equal protection and benefit of the law. They've benefited from the law in the sense that they are now out on bail, and however long this case will take to get to a hearing date and a sit down, that is how long they will enjoy their liberty. And so it contravenes the equality clause of the Constitution to have her not enjoy those same rights when all the accused in this matter are more or less being tried for the same crime. She's not being tried for a crime that her co-accused are not being tried of. And so quite apart from all the other accused that have enjoyed the protection of Section 660 of the Criminal Procedure Act, just within her case, every single other accused is out on bail. If perhaps there was 1 or 2 accused of the 18 that was still remanded in custody, then it would make sense. But to have her be the sole person or sole individual amongst these accused being detained, it contravenes, or rather it defeats the purposes of the Constitution, and also it contravenes Section 12 and Section 35 of the Constitution. So we make that argument under the paragraph that deals with what our case before this court has been, and why it is that we've leaned so heavily on the Constitution and read it with Section 60 of the Criminal Procedure Act. We then, at paragraph 18, directly ask this court to consider itself bound by the provisions of Section 39(2) of the Constitution, and to interpret the Criminal Procedure Act and this bail application in a way that promotes the spirit and purpose and object of the Bill of Rights. That specifically pertains to the judiciary's role in matters like this. It is trite that the the magistrate's role in bail hearings is inquisitorial, and so we add to that being inquisitorial, it also needs to promote, or be done in such a way to promote the spirit and purpose and object of the Bill of Rights. We then come to dealing with, at page 7 of our heads of argument, the state's opposition to the granting of bail. Your Worship, there is not a single thing that the state has not tried to find in terms of adverse evidence against Ms. Cholota in this matter. There have been claims that although the state does not know what immigration issues she's had immigration issues. Although there was a boyfriend from 2021, she's an unfavorable character because she never mentioned that boyfriend from 4 years ago. There's been claims that because she did not exactly set out the exact school and a house that her son would live in, she obviously does not have a close enough relationship with her son There was also claims that because her family lives here and she was living in the United States and she did not come back for 4 years, she clearly does not enjoy a close enough relationship with her family. All of those allegations and assertions by the state not only are irrelevant, but are rather absurd, thinking about the actual thing or the actual ground that they purported to oppose this application on, which was flight risk. None of those things have her intentions with her son have got nothing to do with her being a flight risk. She put in her papers that she has relatives overseas. That's what the act requires, that you state what relatives and what friends you have overseas. She stated that it was the son, and then went over and above that and told the court that I actually intend to have my son here. We believe that that is more than enough. It was not incumbent on her to inform of every single plan that she has of relating to her son. Equally with the boyfriend, the fact that this boyfriend was observed coming into the interview and now nobody knows the whereabouts of that boyfriend. The absurdity is simply self-evident with that one. However, what the state's actions have managed to do is to infringe upon her rights. The state knew that it did not have enough or sufficient evidence to justify an opposition, but it did it anyway. And in so doing, it infringed upon her right to equality because the accused did not have their bail applications opposed by the state. It infringed her dignity. This entire case, in fact, has infringed upon her dignity and disrespected her right to dignity. And the fact that her fair trial rights under Section 35 were also infringed. But for the present purposes, the main right that we lean on is that under Section 12 of the Constitution, which we feel is under violent attack by the state in its opposition of Ms. Cholota's application. It did not have to launch this attack, or rather this opposition, knowing full well that there were no such facts to support allegations that she would evade trial, but they did so nonetheless. And we state that that is simply an unconstitutional manner of doing things. We state there that in order to prove its case, the state employs various means. They claim that she has a pattern of conduct consistent with someone likely to evade trial, but they do not provide a pattern of that conduct of someone evading trial. She cooperated with being arrested in the US, attending her every single proceeding in the US regarding to extradition. There's no mention from US authorities or otherwise that she resisted her arrest, that she was recalcitrant in being transported back to South Africa. She cooperated with authorities in every way that she could, and that's why we say that. But the state then tries to include the fact that she had said she was going to provide a written statement to Captain Galitz in 2021, but it will be recalled that the circumstances under which that undertaking was made was right after they threatened and intimidated her. And so to place reliance on a statement that was made in that instance is untenable. Rather place reliance on the rest of her behavior, which is from when she was in school in university at the Bay Atlantic University. The Zonda Commission gave her a summons, and they said, we would like for you to come and appear on this date, and we would like you to give evidence on your role in the office of the Premier. They gave her a date, they gave her a location, they gave her correspondence, they followed up with correspondence, and she made herself available. She got onto a flight of her own accord. The state did not pay for that flight, and she came to Johannesburg. That's the pattern of behavior that we should be observing, not the pattern of behavior that has been inferred by the state from various facts that do not prove anything. The second is that the state seems to think that her filing submissions with the U.S. Secretary of State was her appealing her the extradition certification. But the grounds to appeal a certification from a court are mostly procedural, because as we explained in our replying papers, the entire process is procedural. Now, the state would have us believe that there were merits, there was an entire court that looked at the evidence and that said, you know, yes, it seems that she is guilty, there's no doubt about her guilt. There was no such thing. The order that they failed to attach to their papers is clear. It's a procedural exercise, and one could almost even say it's a tick boxing exercise where the court looks at, is there an extradition agreement between this country and that country? Yes. Does the offense that this person is charged with fall under this extradition treaty? Yes. And has this person been arrested lawfully in this country? Yes. And that is all that Magistrate Aslan looked at. She did not look at, are the emails sufficient evidence to prove beyond reasonable doubt that she is guilty of money laundering and corruption and fraud and all that. They say in a footnote that though that is a procedural exercise, the US, however, could not bring itself to extradite on money laundering charges. They do not say it in the papers, they say it in a footnote, and they say it without having said it prior to her legal representatives that these money laundering charges may be dropped because the USA refused to extradite on that basis. We see it for the first time when we're seeing an answering affidavit. And so that again points to this need to present the extradition proceedings as a pre-hearing to the criminal matter, and that she was found guilty in the pre-hearing, and so it is without doubt that she will be found guilty in the post-hearing. That is simply not the case. They also then claim in their papers that I forget the exact quote, but they claim that she disappeared in the United States, and I quote, her location became unknown to the authorities. That is also a misrepresentation of the facts, Your Worship. The email that they attached to their own paper states that we are going to find her address so that when the prosecutor approves her warrant of arrest, as South Africa had requested, then they will go to her place of accommodation. Just as Captain Khaled's here, when he was given the address that she's going to live at should she get bail, just as he went to go and confirm that address, that is exactly what the US authorities did. So it's not that she became, her whereabouts became unknown, as though she had said, I'm at Eitzig, and then all of a sudden was not at Eitzig and was to be found in Grasland. That is not what happened. But again, it is this narrative that the state desires to place before this court to say, this is someone that regularly evades trial, and this is someone that cannot be relied upon. That is simply not true, Your Worship. The email from the Department of Justice spokesperson that they attached even goes as far as to say, the last we checked, she was still studying at her university, and she's in Baltimore. And so there's no indication there that this person has had her whereabouts unknown to the US Marshal. And indeed, when the prosecutor did receive that warrant, they went to the address and they found her there, and they arrested her and they took her to the detention facility. There was no resistance of arrest, there was no unlawfulness of that arrest, there was nothing untoward about that arrest, which is why the US court decided that there was nothing untoward about that. And so it's this running thread, this golden thread through the state's case that appears to really, really be a desperate attempt to make her out as this person who indeed will evade trial, all the while ignoring that the one time that she was given a hearing, that she was requested to come back to South Africa in writing and with proof thereof, she did come back without problem. In a contradictory situation, they then state that there was an Interpol red notice against her and that she could not have come back to South Africa. So on the one hand, they claim that she evaded trial by not coming back to South Africa, and then on the other hand, they want to claim that, oh, in any case, there was an Interpol red notice against her that would have arrested her if she left the US. So what should Ms. Cholota have done? Should she have left and then contravened the provisions of that red notice, or should she have stayed in the absence of a hearing date communicated to her, as should have been the case by the state? They provide quite a lot of evidence to the extent that when they considered her a witness, they knew her email address, they were communicating with her in writing, but they do not provide a single piece of written evidence to show that they actually invited her back to the country to attend trial, and she said, no, I'm not coming back. Instead, its former attorneys said this one gave an undertaking, but no explicit mention that Ms. Cholota was the person that gave that undertaking. And so these attempts to cast her in this light of evading trial must be recognized for the failure to be supported by evidence that they are. And then the state then claimed that she approached the Constitutional Court to set aside the decision to apply for her extradition on nebulous grounds. We state on this, and we will briefly deal with the Constitutional Court. We will not even go beyond a mere sentence. Ms. Cholota had every right in law to review a decision of a minister that she felt was administratively unfair and unlawful. There's no one that is barred from pursuing that course of action, and she did that. And the fact that it was refused on the grounds of urgency, that is what happened in court cases. Sometimes you win, sometimes you don't. Sometimes you're granted direct access, and sometimes you don't. Nothing speaks to the fact that she was so desperate to evade this and evade that and not be extradited that she went as far as to approach the Constitutional Court. There was evidence, as far as she was concerned, that the minister's decision was invalid. The state calls into question Ms. Cholota's state of funds, going as far as to unnecessarily bring up how she is paying for her legal expenses. That, we say, Your Worship, is unnecessary, because not only is that not a requirement in terms of Section 64, it is neither relevant, because if we say she's paying it out of her pocket, then what happens? Do they want our bank statements as her legal representatives? Do they want all her legal representative statements? It was a claim that was made, but it does not appear that the state gave too much thought into making that claim, just for the purposes of making it. And then, Your Worship, there seems to be a lot of statements where the state makes a statement and then says, but we don't have any knowledge of that. The state makes a statement, but we do not have any proof of that. Brief examples of that, we deal with that at page 9 of our heads of argument. They claim we have a lot of evidence against Ms. Cholota, but then when we bring up that the public protector has investigated the asbestos project, the special investigating unit has investigated the asbestos project, the State Capture Commission has, as well as the Auditor General, they then say in their answering affidavit, oh, we have no knowledge of those reports, which we find to be unlikely at the least. They also then claim that the Constitutional Court and the United States Courts and the Deputy Secretary of State have found a case against her, but they provide no evidence of these findings. The Constitutional Court order does not support that. The extradition order, which we still have not seen, does not support that. And there's no court, the US court, that found a case against her. It simply found her extraditable and the certification requirements met. And so this attempt by the state, time and time again, to make statements but provide no evidence, therefore, is clear indication that their opposition to bail was frivolous, it was done in bad faith, and they knew that it was unnecessary from the moment they made it. However, they wished to do what the courts have asked the state not to do, which is to use bail as a punitive measure. They knew they did not have a case, but they knew that if they opposed bail, that she would be detained for a day longer, a week longer. As it currently stands, she might be spending a second weekend in prison. Again, 10 times longer than any of her co-accused have. And so we submit that they knew they did not have a case, but that it was necessary for them, once again, to treat Ms. Cholota in a manner that is inhumane, that is cruel, and that is tantamount to degrading treatment. We state in closing, or rather close to closing, that the state appears to treat this matter as though it was a Schedule 6 bail application. They seem to want Ms. Cholota to produce facts on exceptional circumstances, but that is not what the law requires. If it's Schedule 5, the law says it's interest of justice. There's not an elevated scale simply because persons are of that opinion. It is, if it's Schedule 5, then it's the interest of justice. If it's Schedule 6, then it's exceptional circumstances. But the manner in which the case that they have brought against Ms. Cholota is termed, it is as though she needed to have provided facts that would support exceptional circumstances, and that simply is not the case. Over and above this, they also fail to even meet the balance of probabilities on their opposition. And so they want a higher level of proof where Ms. Cholota is concerned, but they themselves fail to even meet the low bar of a balance of probabilities, which is untenable. And just to close, Your Worship, by quoting a relevant judgment in Mohammed, that was an extradition case that the Constitutional Court dealt with the other way around. So where it was a South African, this time extradited back to South Africa. In Mohammed, it was a fugitive or a terrorist accused that was being extradited from South Africa to the USA. But therein, the agents, the South African agents, from the prosecutors to the police, to the people that were required to exercise care and exercise their constitutional duty in arresting the persons, committed certain unlawful acts in the arrest of Mr. Mohammed. And this is what the Constitutional Court said. And we set it out here because that was someone who was not a South African citizen, and the Constitutional Court was this concerned for their well-being. And we state that equally, Ms. Cholota's well-being should be of even more paramount. There it says, we saw in the past what happens when the state bends the law to its own ends, and now, in the new era of constitutionality, we may be tempted to use questionable measures in the war against crime. The lesson becomes particularly important when dealing with those who aim to destroy the system of government through law by means of organized violence. The legitimacy of the constitutional order is undermined when the state acts and constitutionality and actually counts against what they're trying to do, which is corruption. Considered to that she big trial that the injustices do oral argument in support of the bail application, Your Worship. If there are no clarities or questions.
Thank you very much.
Thank you, Your Worship.
I'll receive the heads of argument. It will be Exhibit E.
As the conferences.
That's good and nice.
Thank you, Worship. I'll do my level best to keep it as short and painless as possible. Firstly, on a lighter note, I must say that I didn't realize that the organization that I work for, being the NPA, as well as myself and the members of the Hawks, are such villains. But on a more serious note, I reject all the attacks and allegations against everybody involved in this matter. Now, just to answer briefly to my colleagues' arguments. Firstly, it is extremely important that the past conduct and the history of conduct of an applicant be taken into account when considering bail. Look at the past to attempt to ascertain or envisage what this person might or might not do in future. Then secondly, important is the nature of the onus. In this case, the onus to prove is on the applicant. Now, with all respect to my colleague, it would appear that there is a shift in her, when she argues, she basically says there's a shift in the onus. The state didn't prove this, the state didn't prove that. That is not correct. the state doesn't have to prove anything in this case, apart from showing to the court that this person is charged with certain charges, which causes section 6011 to become applicable. It is for the applicant to discharge the onus. Together there, with that is, of course, the nature of the crimes. Now, anyone who would allege that these crimes for which the accused is charged is not serious, it just won't hold water. It is extremely serious. Then further, my colleague indicated that this is basically a dress rehearsal of the trial. Your Worship, with the utmost of respect, this is very far from a dress rehearsal. It has to be borne in mind that from the outset, the applicant stated that there is no or very little evidence against the applicant. That is why the state elected to place a lot of evidence before this court to outline where the allegations come from, where the charges emanate from against this applicant. Excuse me. The applicant, through her advocate, indicates that she wants to attend the trial. Now, with respect, everything that she did in the past few years indicates precisely the opposite. If she wanted to attend the trial, why didn't she come back to South Africa? After an undertaking was given in a high court before the judge president in Bloemfontein, why didn't she? Why did she oppose her extradition application? Why was extradition even necessary? Why did the state have to go to all the trouble? Burdening the Department of Justice in the US, filing hundreds and hundreds of pages of papers with the United States Department of Justice. My colleague indicated that it took the state 5 years to get a trial date. Your Worship, with respect, we would have had a trial date a long time ago. We would have been busy with this trial already had it not been for certain of the accused, co-accused of this applicant, who brought a number of applications in the High Court, which were dismissed. Thereafter they appealed, and thereafter also approached the Constitution. Now, of course, all these applications and judgments and so forth take time, a lot of time. And that is the main reason why we struggle to get a trial. Now, in a sense, it worked in the favor of the state, or to the advantage of the state, because in the meanwhile, Ms. Cholota was extradited, and we can now add her to the indictment. Had this trial commenced sometime in the past, we would have had to prosecute Ms. Cholota on her own. The argument is that the United States didn't look at the evidence. Now, if one looks at the memorandums outlining the application by the prosecutors in the US, it is abundantly clear that they looked at the evidence, the available evidence and the allegations by the state in South Africa in detail. They looked at it in so much detail that they did not even allow extradition on all the charges for which he was initially charged. For instance, the money laundering charges. And my colleague says that it was only much later in this week that the state indicated that the money laundering fell away. Now, I believe we were in the same court since Monday. That is one of the first things that I said. When I handed the indictment to your worship, I said she was extradited on the following counts. I indicated to the court that she was not extradited on money laundering. The main fact being that their legislation pertaining to money laundering differs somewhat from the Prevention of Organised Crime Act in South Africa. For instance, negligence is sufficient in South Africa to prove money laundering, which they do not have in the US. So no, Ms. Cholota knew from Monday, at least from Monday, precisely what counts she faced. It is stated that no one is barred from taking a matter to the Constitutional Court. Of course not. But the question must be asked, why? If you want to come to South Africa and you want to prove to the world that you are innocent and you want to correct your reputation or something to that effect, then you don't oppose the process. Then you come to South Africa and say, yes, here I am. You don't fight the whole process on each and every step of the way. It has to be borne in mind that the US viewed her, excuse me, as a flight risk. They kept her in custody. Towards the end of the argument, it was stated that the state does not meet the threshold of the interest of justice. I say again, it is not for the state to prove. It is for the accused, the applicant, to prove that it is in the interest of justice that she be released. Your Worship, then, I would just like to refer to the replying affidavit, which was filed this morning. I look at page 3, paragraph 10, where it is stated, instead the state inserts paragraph 4.1 in its papers, which reflects an amount of 86.5 million that is not found anywhere in the current charge sheet. Now, and then thereafter comes the interesting part. I am advised that this is an appalling display of the state's disregard for lawful and constitutional criminal procedure. Where on earth the defense got that line? Only they will know. Now, either, with respect, they didn't read the indictment, or they read it but didn't understand it. If you look at the indictment, and yes, it is a voluminous document, 104 pages, I believe. It is important, as I indicated to the court on Monday, that the court, and by implication the defense, take cognizance of the summary of substantial facts and the preamble. Of course, that reads like a novel. It sets out all the allegations against every one of the accused, and it also gives an indication where each accused fits in this whole conspiracy common purpose scenario. Now, counts 1 to 8 And I have indicated to the court that the Americans, excuse me, did not extradite on all the counts. I did refer to which counts. But that must be read together with. What will just bear with me a second. Page 92. If one adds up the amounts on which she is now standing, or on which she will stand trial, and for which she was extradited, then it amounts to 86.5 million. So no, the defense won't find an amount of 86.5 million in the charge sheet. You must do a little bit of math first. Paragraph 18. The allegations contained in these paragraphs present an attempt by the state to distort the information relevant for this honourable court in making its decision whether to refuse or grant bail. I reject that. Now, paragraph 26, page 6. The intention in that has always been to degrade, humiliate, and effect cruel punishment. Now, one looks at the affidavit and the findings by the court in the US, as well as the dismissal by the Constitutional Court of her application. It is clear, Your Worship, in my view, that this applicant was actually wrapped in cotton when the detectives went to see her in the United States. When she wanted to see a lawyer, it was immediately asked for one. When she wanted a boyfriend to attend, she was given that opportunity. So, this whole narrative of degrading and humiliation and cruel punishment, with all due respect, there is no basis. There's a big noise made from page 9, paragraph 36, that the state so-called fabricated information pertaining to her contact with the outside world or another country. At that time, we had the information that she had links to Kenya. That later, it became evident that it was in fact Nigeria. Now, for purposes of this exercise, it is actually of academic importance because she doesn't deny it. She says, I indeed have links to Nigeria where my son resides. Page 10, paragraph 41. The state indicates in these paragraphs that it appointed a private company, FTI Consulting, to undertake a forensic investigation of me. Now, where they got this information from, only they will know. The document that that was attached to the affidavit of Captain Carlos is an extract of a much bigger report by FTI. I could tell the court that the FTI report, together with its annexures and exhibits, comprised more than 30,000 pages. That's why we took an extract showing the involvement of this lady. I didn't dump everything before this court because it's not relevant. But to say the state appointed a forensic audit firm to investigate her is totally false. she is only but one spanner in a much bigger, one cog in a much bigger engine. And with all due respect, to put it bluntly, Ms. Cholota is not that important that I would request a forensic audit firm to investigate only her. Page 11, paragraph 48. It is an unnecessary waste of public funds and was clearly a futile waste of time, as nothing in FTI Consultants' forensic report links me in any way to the asbestos project. Now, again with respect, either my learned colleagues didn't read that report, or they read it but they don't understand it. It is quite complex. Your Worship, I'm not going to refer to each and every allegation in that report, apart from stating the following. If Your Worship, for instance, looks at, and that is Annexure AA11, page 16 of that report, Makwena's daughter's school fees. That refers inter alia to count 15 of the indictment. And there's a whole explanation of what happened there and the specific involvement of the accused. How can they say that there is no evidence whatsoever linking her to the asbestos matter? On page 21, Griffin Edge, the whole issue pertaining to the payment to Griffin Edge refers to count 17 in the indictment. Page 22, the so-called Cuba trip, count 19, and so forth and so forth. Now, what is in addition extremely worrying and significant is the fact that the applicant had two bank accounts. The one where the normal transactions took place, where the salary was paid in, and so forth and so forth. And then she had a capital, which we, or rather the forensic investigators, only found some time later. It was like a little secret account. And I say secret because if Your Worship looks at the payments going in and out of that account, Your Worship will see that this honorable lady, as she wants to report herself, received thousands of rands from different service providers who did business with the Free State government. Illegally so. Now, she wasn't charged for this in this case, not yet in any way. But that is important for purposes of this bail application, because it shows to the court, and I'm referring to from page 53, it shows the character. It shows the kind of person that Your Worship is dealing with. FTI made a summary. On page 50 and 51 to 52 of that account. Just want to refer to a few entries. On page 50 at the bottom. Cash deposits into that account, 135,000 rand. More than 135,000. Inter-account transfers, 1.5 million. Next page, page 51. ANC stroke Magashule link, 19,500 rand. Look at under the heading contractors. ETSO Civils, a service provider to the Free State government, 8,000 rand. DAB Consulting, 10,000 rand. This is totally illegal. So what I want to indicate to the court that this applicant attempting to show that I'm this honorable person and I want to come to South Africa to prove my innocence was busy with a lot of underhand dealings. I wish to also just refer very briefly on page 1 excuse me, of annexure AA11 at the bottom there. This is a finding by FDI. We found that Magashule and Cholota had a relationship that stretched beyond the normal duties of a personal assistant and that she was entrusted with private matters of the Premier. I quote, the relationship was woven between service providers, government officials, and other persons and entities. Most relationships have a financial implication on the parties participating in such relationship. Excuse me, relationships, and often the financial implications on the parties are interrelated. Without going into the detail of what the state will prove in the High Court when this trial commences, this gives an indication of where this applicant fit in the bigger picture. She was right up there with the Premier at that time. He gave her orders according to our information and the evidence that they have. He said, contact Mpambani, tell him to pay X, Y, and Z. Now Mpambani had a company which was a service provider. And as we indicated in the indictment, as shortly as, or as soon as 15 or 20 or 30 million rand is paid into their account, then the emails run from this applicant, telling Mpambani, now he must pay, amounting to more than R1 million. The part that I referred to pertaining to a bank account, and I'm referring to page 2, paragraph 2 of the FTI report. Magashule and Cholota used their positions to either solicit payments from service providers for the benefit of other government officials or possible own benefit, or to defraud the department and to misappropriate funds earmarked for student bursaries. Now, I don't even want to go into the detail of this student bursary scheme, apart from saying that she was not a person who was supposed to get a bursary. It was for previously disadvantaged people. But it was so manipulated that she got a bursary, and even Magashule's son got a bursary. Now, how untoward is that? Cholota opened an additional bank account in 2013, receiving unknown cash deposits, transfers from service providers, individuals related to service providers, ANC members, individuals with close relationship with Magashule, excuse me, and other government officials, mainly within the office of the Premier, which were not disclosed to the authorities. Then, paragraph 5 of the same page, excuse me, payments for the Free State Asbestos Eradication Project to the Blackhead Consulting Diamond Hill JV were made during the period 2 December 2014 excuse me, to 10 November 2015. It was during this period that Mpambani and Sori. Now, Mpambani was shot, assassinated in Sandton, there on the pavement. So he's very dead. But Sori is accused number 3 in the High Court. It was during this period that Mpambani and Sori managed their relationship with Magashule and Cholota. Mpambani received several requests from Cholota for financial assistance for inter alia students, government officials, and ANC delegation visits, which was funded by Blackhead Consulting, Diamond Hill Consulting, and all 605 Consulting. This is textbook examples of corruption. But then, with due respect, the defense tells the court that there is no evidence in this forensic report implicating this lady. It is very far from the truth. Excuse me. David, paragraph 57, the state did not the trial itself showed no sign for hearing. We didn't abandon it. The Americans would definitely not have continued with this extradition had we abandoned it. It is a mountain of work to apply for extradition, and it is a mountain of work to consider it by the prosecutors in the US. Now, this whole issue pertaining to her initially being a state witness. Now, page 16, there is a quote from email correspondence between myself and Ms. Cholota and with Brigadier Gerber. Now, I feel it was unfair to me, stated by her, when the prosecutor announced in court and in front of TV cameras that I am a state witness without my knowledge. We don't have to broadcast, tell the whole world who is going to be witnesses. But at that time, I had to disclose it to the court because we didn't want, for instance, Magashule to have contact with her. Because of the close relationship that existed during the committing of these crimes. So I had to disclose it. She also stated, I feel like you are ordering me to be a witness on something that I have no intimate knowledge about. How on earth? You get an instruction, you write an email, but now you say you've got no intimate knowledge. Doesn't hold water. Page 18, paragraph 87. This email exchange, excuse me, which the state attached to its own papers, shows that I never consented on my own accord to be some sort of special witness for the state. She wouldn't have been a special witness. I don't know what's meant by that. But in any event, you don't have to consent to be a witness. She doesn't understand the criminal procedure in this country. If a person is identified as a witness, he or she can be forced to testify. Section 189 of the Criminal Procedure Act. If every witness had to give consent before being approached, I wonder if we would have witnesses in this country. Especially in some of these horrific murder cases where people have to testify on a daily basis. Paragraph 97, page 20. That paragraph 97 and all the sub-paragraphs, with all due respect, should be rejected with contempt. For instance, 97.1, the state will give assurances as to what they require testimony on and turn around and renegade on these assurances. Had Ms. Cholota, during the interview with the detectives in America, tell them the whole story truthfully and correctly, she would not, in all probability, would not have been sitting there today. It is clear from the affidavit of Captain Cards that this potential witness made an about turn. Just bear with me a second. There was reference made to the judgment of the Supreme Court, the High Court in the Free State in the matter of Nandipa Mabubumana. I wish to hand up a copy of this judgment for the court. It's to make it a lot easier to follow. And mention was also made to the judgment of Sivela versus the state in the Supreme Court of Appeal. Now, without repeating everything in page 6, paragraph 7, I implore the Honourable Court to look at what was found there. The favourable personal circumstances of this applicant, or appellant, compared to this applicant. Also a fraud case, also Schedule 5, and the appeal court dismissed the appeal. My lady, yes, sorry, Your Worship, that concludes my argument. I am of the very firm view that this applicant did not discharge the onus. Very far from it. She is most definitely a flight risk, and bail should be denied. Thank you.
The defense?
Thank you, Your Worship. Your Worship, before we broke for lunch, after we read our replying affidavit into the record, Your Worship asked Mr. Advocate Dineshan if he would like to file an affidavit in response to our replying affidavit. The lengthy submissions which we have just been subjected to are responses to our replying affidavit and not arguments in favor, or rather in support of their opposition. And so I would like to just find out what the status of his submissions right now are. Are they to be deemed as arguments in response to our heads of arguments and oral arguments, or are they to be deemed as viva voce evidence being submitted in response to our replying affidavit in support of the state's case? And if so, is he the deponent, or is the deponent that was the deponent in the answering affidavit, which was Mr. Khalid's? Because that would then direct us as to how we are to proceed. because there was evidence being led orally in favor of the state against allegations that we had made in the replying affidavit. And we just wish to understand what the status of these submissions are.
Thank you. Applicant Nyson.
Yes. Thank you. Your Worship, the position is very clear. It's not evidence, it's argument. We already have a comprehensive sworn affidavit. Captain Collins, I elaborated thereon, and indicated to the court that in the light of the findings, his affidavit, and so forth, that this supplementary affidavit, much of the contents is not correct as a present.
Thank you, Advocate Collins. In that case, then, Your Worship, we only have 2 points to make with regard to the submissions that have been made by the state. Nowhere in any of the submissions that were just made was anything said about the interest of justice and how they would be denied if Ms. Cholota were to be released on bail. What we heard instead was a lengthy regurgitation of what we have said time and time again in this case. That, which is what they say in the Constitutional Court papers, which is what we said, that the fact that Ms. Cholota did not attribute certain instructions to her former boss had the result that she was then charged or treated as a suspect in relation to some of the charges that Mr. Magashule, her boss, was facing. One need only to have listened to a few seconds of the submissions that we have just heard to understand the bias against Ms. Cholota for her refusal to say anything that would support this evidence, none of which is charged, none of which has been investigated by the state's investigators. All we heard was FTI consulting, FTI consulting, FTI consulting, a report, a forensic report that was done only 8 months ago, or is it 10 months ago, when her charges were brought in 2021 and her extradition application was brought in 2022. And so Ms. Advocate Collins correctly proves our case that all of this has been done so that she could depose to affidavits implicating these people and corroborating this evidence from investigators that we do not even know where or how they got this evidence that they so confidently rely on. Other than that, we reiterate that no basis, no case, no evidence, no facts have been put up by the state in opposition of Ms. Cholota's bail that would warrant the denial of her release on bail. Having said that, Your Worship, if there are no clarifying seeking questions, that is our case in support of the bail application.
Thank you.
Your Worship, I have nothing further except to congratulate my investigating officer in his promotion to advocate.
Thank you. The two cases that was handed up by the states is received. All I want to say about that is the Magodumane matter is well known to me. I was the magistrate who was dealing with that matter at the time. So I do not need to read the matter and the result because I'm aware of it. And I'm also familiar with the other matter that was handed up. It is Exhibit G.
As a police report, I was not aware. It's just for ease of reference.
The state's arguments in opposing bail is marked Exhibit H. I see it is already 2:30 in the afternoon. I'm not going to waste any further time. I'm going to proceed with judgment. Thank you. The applicant, Ms. Cholota, is applying for bail. She was represented by Advocate Makapela. The state is represented by Advocate Denison. The applicant is charged with fraud and corruption resulting under Schedule 5 of the Criminal Procedure Act. The state and the defence both agreed on the schedule, and we proceeded with it as a Schedule 5 offence. The law states that the applicant must be given a reasonable opportunity to satisfy the court that the interest of justice permits her release on bail, and the onus of proof is on her to prove it to the court on a balance of probability. She applied for bail by handing in an affidavit, and the state requested an opportunity to prepare their papers until the next day, and the defence inquired from the court if they will get an opportunity to reply to the affidavit by the state. I must just also now further add that it is unusual for a court in a bail application to receive replying affidavits. It's normally just the applications, and it must be comprehensively done to cover all aspects. But I do have a discretion, and I decided to allow that, and I will now just give a short, brief reason for me allowing that under these particular circumstances. I don't normally do that. When the application started, the defence handed to me the indictment, which already indicated to me that the matter that she's facing will be transferred to the High Court immediately upon conclusion of the bail application. The court is also fully aware of the fact that should bail be refused by the court today, and there are new facts that arise to bail on new facts, and the matter is already in the High Court, I will be precluded from hearing the bail on new facts. So it is very important for us to air each and every aspect in this bail application now, so that there is no reason why it should come back, or an attempt made to come back to the school to deal with an application on new facts. So that is why I allowed it. And the second reason is because the state did not have their affidavit ready and prepared. So it was not available to the defence. They couldn't peruse it beforehand to amend their application in accordance with that. And it is only fair that the applicant be given a reasonable opportunity to satisfy the court that it's in the interest of justice to be released on bail. And she can only do that if she also has access to the affidavit by the state. So that is the two reasons why I decided that I'm going to deviate from the normal procedure. The state returned the next day and handed an affidavit into court, reading it into the record, indicating that they are opposed to bail, and mentioned that the main reason for them being opposed to bail is the fact that they regard the applicant as a flight risk, and that there is a likelihood that she will not stand trial. And they listed various reasons in the affidavit for that conclusion that they made. At the end of that, the defence did not have a replying affidavit ready, and they indicated to the court that they need time from Tuesday until Thursday to draft the replying affidavit. The defence did express their dissatisfaction to the court for not allowing them to present their submissions orally, but it is important to note that the replying affidavit cannot be presented by the defence by addressing the court from the bar. It can only be done by an applicant deposing to an affidavit or by otherwise testifying under oath. However, the matter was postponed until today, and the affidavit was handed in today. It was a comprehensive affidavit And I want to also just say to the defence, I appreciate the time that I put into that to have it ready for us today so that we can proceed with this application. The state and the defence both presented their arguments today. They were heads of argument, and they also elaborated on what was contained in their heads of argument. Now, if I get to the application itself, the applicant placed her personal circumstances before the court on record. She also indicated that she does not have family members, that she has family members in Bloemfontein in this area, and that she will be living with them if she is released on bail. She was extradited from the United States, where she was studying at the time, and she was brought back to South Africa. She was in the United States unemployed, and she used her bursary money to, not the bursary money, but the funds that that university provided to her to study with, to also support herself at the time, because her bursary from South Africa had been cancelled. She is still unemployed and can only raise an amount of 2,500 rand bail, but if need be, she would be able to raise more. She explained that her travel documents and her passport remained behind in the United States when she was brought to South Africa, and emergency travel documents were issued to get her to South Africa after she was, the extradition proceedings was successful. She had no previous convictions, pending criminal cases against her. She also intends to plead not guilty to the charges against her. She's not a danger to the public or any individual. She will not attempt to evade her trial. The State Advocate Denison read the investigating officer's affidavit into the record. It is also quite a lengthy affidavit, consisting of a number of pages. And that already is a clear indication against the applicant in order to charge her, because they are going to proceed against her in the High Court. The state opposed the bail on allegations that she's a flight risk and there's a likelihood that she will not stand trial, and this is based on the actions of the accused, who had to be extradited, and she opposed the extradition proceedings. She had attorneys present and advocates representing her. She also filed papers with the Constitutional Court requesting direct access to them. This was refused, and the state basically claims that all the legal avenues that she followed to try and prevent the process being followed against her was to waste time. The bulk of the affidavit, the rest of the information, contains information regarding the charges against her, the extradition proceedings, and so forth. I'm not going to repeat any of that because we are all fully aware what is contained in it. It was also made available to all parties and to the media, so they also have access to that. The defense responded to the state's affidavit with an equally lengthy response, indicating different or giving different explanations for all the allegations made by the state in the affidavit, dealing with a point-by-point basis. She also deals extensively in her affidavit with all the issues also including the fact that there's an allegation that she's a flight risk and that she will not attempt to evade her trial. And in an affidavit, she also explained her presence in the United States and why she was there and where she was at all times while the investigation in this Magashule case was busy going on. This was the applicant's case. I'm not mentioning everything just to save time, but this is the most important aspects which I am taking into account in this decision. The state and the defence then also just addressed me, and I must mention that Section 60, subsection 4, contains certain grounds that the court should take into account in deciding whether it is in the interest of justice to grant bail to the applicant or not. Now, the first ground is if there's a likelihood that the applicant, if she is released on bail, will endanger the safety of the public or a particular person. That is not a ground that the state relies on, but they are relying on the second ground mentioned here under subsection B, which is a likelihood that if she is released on bail that she will attempt to evade her trial. And that is, the others are also not applicable because it's not, the state does not have any fear that she will commit any of those. Now, in considering whether the ground in subsection 4B has been established, the court may take into account various factors, and it's also listed there. The first factor that is listed is the emotional and family, community or occupational ties of the accused in the place where she is supposed to be tried. Now, she's going to be tried in Bloemfontein. She is a South African citizen, although she's studying in the United States. She was also there for about 4 years. She has family and she's got friends in South Africa. Although she was away for 4 years, it doesn't mean that they do not remain her family and her friends in this country. The assets held by the accused and the places where the assets are situated is she owns fixed property in grasslands in Bloemfontein, and she is renting that property out. The third factor is the means and travel documents held by the accused, which may enable her, they refer here to the accused, the applicant, which may enable her to leave the country. At this stage, she has no travel documents in her possession. It was left behind in the United States. Fourthly, that's under subsection D, the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set. At this stage, her real financial means is not known to the court. She indicated that she's unemployed and that she will stay with family members. The question whether the extradition of the accused would readily be affected if she attempts or flees across the borders of the Republic, it is not possible to make any remarks on this aspect because if she is going to flee, we do not know where she's going to, so the court must rather look at is there a possibility or a likelihood that she may flee. The nature and the gravity of the charge or the charges which the applicant is to be tried for. The applicant is facing charges which are of a serious nature, and it is evident by fact that it will be tried in the High Court. It relates to elements of dishonesty, but it does not include elements of violence. The next factor under subsection G is the strength of the state's case against the accused and the incentive that she may have in consequence to have an attempt to evade trial. There is sufficient evidence to charge her. As already said, there is an indictment, and if the DPP decided to charge her, they must be satisfied that there is sufficient evidence to charge her in the High Court. The information that was revealed in the bail application was that the applicant was initially approached with a view of interviewing her in order to convince her to become a state witness, or to consider her as a state witness at least. And then she at one stage cooperated, and after that she did not further cooperate. And this was clear to the court as well, that it was to the dissatisfaction of the investigating team. A decision was taken to investigate further, and she was then charged. The charges flows from her involvement and actions that was taken by her while she was the personal assistant of the previous Premier, Ace Magashule. And he will be standing trial with her on fraud, corruption and money laundering charges in the High Court, together with a number of other accused. Under subsection H, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against her. If she is convicted, we all know that there is a minimum sentence applicable. She will most probably be sentenced to a period of direct imprisonment if convicted. The next factor, I'm going to take the last two together for this purpose: the binding effect and enforceability of bail conditions which may be imposed and the ease in which such conditions could be breached, and any other factor which in the opinion of the court should be taken into account. I take into account that it is possible to fix bail conditions which will limit the possibility of the applicant fleeing from the country and even to limit the movements of the applicant from within the Free State province. I do not find any evidence. If I say I find any evidence in this affidavit of the state to support the claim of the state that the applicant is a flight risk and that there is a likelihood that she will not stand trial. She was a resident and a student in the United States at all times. There is no evidence that it was difficult to get hold of her when she was needed. It appears that there was a regular communication between her and the state and her previous legal representative and the state to a point, and then the legal process with regard to her came to a standstill for quite a while. At one stage, her address was apparently not known to the authorities in the United States, but she was also located in order to start the extradition proceedings. The applicant indicated that she was at all times still a student at the university attending classes. I do not have any evidence from the state that there was an instruction issued that she must inform the investigating officer of any change of residential address if she does that. So in the absence of her being charged of an offence, she had freedom of movement. It's important to remember that there must not only be a suspicion of a flight risk or a fear of a flight risk, but there must be a likelihood that she's a flight risk and that she will not stand trial. This likelihood must be based on evidence. The court must also take into account subsection 9 before coming to a final conclusion, and that is reading as follows: in considering the question in subsection 4, the court shall decide the matter by weighing the interest of justice against the right of the accused to his personal freedom, and in particular the prejudice he or she is likely to suffer if he or she were to be detained in custody, taking into account where applicable the following factors. The first one is the period for which the accused have already been in custody since her arrest. We've calculated approximately 4 months. Most of that was in the United States. She started her bail application on her first appearance in court. The accused, the probable period of detention until the disposal of the conclusion of the trial if she is not released on bail. If I look at the charges and the number of the accused, the amounts that's involved, it is safe to conclude that this will be a lengthy, drawn-out trial which could take several months or even years to finalize. The next factor, the reason for any delay in the disposal or conclusion of the trial and any fault on the part of the accused with regard to such a delay. It appears from the replying affidavit that the applicant is not the cause of the delay for the trial, and it is supported by the arguments presented by the state as well. The delays were caused by a co-accused bringing different applications in the courts in South Africa, and this fits in with the version of the applicant that there was a long period in which she was not contacted regarding her being charged, and this was the period in which she apparently changed her address. Any financial loss that she may suffer Her life will come to a standstill if she's detained in custody until this matter is finalized. Now, she's also being supported by a legal team, so there's also nothing preventing them from consulting with her and preparing for trial, so it is not anything that can count against the state. Any other factor is the fact that the applicant made use of all the legal resources available to her while she was still in the United States and also now in South Africa in order to defend herself. This is not a factor that can be held against her. She has a constitutional right to have access to the law and to the legal proceedings, and it may not count against her at all if she relies on her rights as a citizen. And it does not mean, and the court cannot come to the conclusion that as a result she's a flight risk. The defense offered an explanation why they abandoned her bail application in the United States, indicating that there were false allegations made against her about her connections in other countries. This was not disputed by the state, although the state was given the opportunity to do so. After all of this, I am indeed satisfied that the defense proved to the court on a balance of probability that it is in the interest of justice to grant bail to the applicant, so bail will be granted. So the only aspect that we are now going to deal with is the amount of bail and possible bail conditions. So can I just hear from the state the bail conditions that you would like to be imposed on the
As a
applicant?
pleasing report, that the applicant not travel beyond the magisterial district of Bloemfontein, that she reports to the Park Road police station daily between 8 and 10. Very strict, thank you.
8 to 10,
Excuse me.
you said between the time 8 o'clock in the morning until 10 at night, or 10 in the morning.
10 in the morning.
Can I
It
hear?
can be amended, it's not cast in stone.
No, it's fine. Advocate Gabriela, can you please address me firstly on the amount of bail?
Your Worship, we, in our replying affidavit, made examples to instances where the state has understood the present financial circumstances of an accused, quite apart from their usual financial circumstances, in using the Pistorius case, where he was granted 10,000 rand bail, owing to the fact that she is still currently unemployed, but mostly due to the fact that most of her belongings are still in the United States, and so she just simply does not have any financial means for anything at this point. And the amount of bail that we had suggested previously, we submit that that should be the amount of bail that it is set at. Yes, that is what we submit here, Your Worship. She is presently just unemployed, no connections or means to support herself whatsoever, other than from her family, which we do not understand is a wealthy family. They do what they can as middle-class families, and so that is, I think, the amount that is appropriate in the present circumstances, Your Worship.
The bail conditions?
Your Worship, we stated in our founding papers that the applicant hails from Bloemfontein and Parys. We were emphatic in that. In fact, most of the family members in the courtroom currently today and in the bail proceedings have all traveled from Parys, where her deceased mother and deceased father were from. We think it would be rather punitive to ask her not to visit Parys, particularly now that she is back in South Africa, and would beg the court's leave to have the jurisdiction rather be the Free State, or rather up until Parys and no further, rather than simply Bloemfontein. But we are indebted to the court and we are subject to the court's discretion.
And the reporting conditions?
Would that be daily? The advocate for the state did not mention whether that would be daily. He simply mentioned the time.
No, he said daily between 8
Daily.
and 10.
We think that is rather stringent, Your Worship, given particularly that this is a Schedule 5 offence. We think that a daily reporting schedule is more suitable for a Schedule 6 offence. We would be more amenable to a weekly or a reporting period of every few days. But daily is rather stringent, particularly considering she will be living with people who are working every day, and we do not know how she will be able to get from Eitzig to the police station every single day, and perhaps leeway could be afforded to her in that regard.
Park Road Police Station is close to us.
So it's
Correct.
as the court pleases.
I'm going to now continue with the amount of bail and the bail conditions. Once a court decided to grant bail, the court must now decide whether the bail is affordable and take into account various factors. The accused is able to raise an amount of 2,500 Rand bail, and therefore the court is granting bail in the amount of 2,000 Rand bail, 2,500 Rand bail. Bail conditions are that the accused will appear in court on every postponement date, 8:30 in the morning. She shall stay present in court until her name is called. The accused may not leave the boundaries of Bloemfontein without the consent of the investigating officer. So you have to contact the investigating officer if you want to go and visit your family in Paris, and just inform him of that and just keep him up to date with your movements to wherever you go. So you have to inform, and the investigating officer must give you consent. The accused shall report to the Park Road Police Station every Monday and every Friday. So it's twice a week, every Monday and every Friday, between the hours of 8 o'clock in the morning and 5 o'clock in the evening. Every Monday and Friday, any time between 8 o'clock and 5 o'clock in the afternoon. If you do not comply with any of these conditions, there will be various options available. If you do not come to court, a warrant of arrest will be authorized for your arrest. Your bail will be provisionally forfeited to the state. If you do not return after 14 days and your bail is finally forfeited to the state, you will be kept in custody. And that will then be until the matter is finalized. The other consequence of not complying with bail conditions is also that the state may bring an application for your release on bail to be withdrawn. And there are certain grounds upon which they can do that. That will then be an application in court to have your bail withdrawn and for you to be kept in custody. Do you understand the bail conditions?
Yes, I do.
Thank you. Senator Nyssen?
As it pleases the court. Your Worship, I need to arrange a date with the High Court for a pre-trial for this accused. So I would like to ask just for a postponement until tomorrow so that I can just contact the judge's office of the Judge President so that we can get a date when she can appear in the High Court for a pre-trial. Thank you.
Defense?
Could I just get clarity on that, Your Worship, you would like a postponement of these proceedings?
Yeah, just until tomorrow to get a High Court date.
The suggestion from my attorneys, Your Worship, is that since it's still 3 o'clock and we still need to deal with the issues of bail, would it not be possible for Advocate Denisian to make his arrangements and then inform the court thusly instead of one more night in custody for Ms. Cholota? However, we are indebted to the court and will be under the court's direction.
Yeah, she won't be in custody.
Ah, I see.
Yeah,
That
no,
is-
she
but,
pays her bail and she's out.
And
Yeah.
do we still need to return?
I know that you're not from here. You're not local, so I don't
But
know.
we could stay if need be, Your Worship. We
It is
had
just to
to-
transfer the matter to the High Court. So it's just a formality, a transfer.
Yes, we are not opposed to that, Your Worship. We agree to that.
Thank you.
As the court pleases.
So the matter is then postponed until tomorrow, which is the 16th of August. You have to be back at court at 8:30 tomorrow morning at this court. And that is just for a matter to be transferred to the High Court. If you pay your bail, you will be released immediately and you have to return again tomorrow morning, 8:30 in the morning. Thank you. The court's adjourned. Have you got muscles? Have you got muscles?